And next, we're going to have an informational hearing on Representative Lesch and O'Neill's proposed amendment to the House rules. If Representative Lesch and Representative O'Neill could come forward. And again, this is informational only, so there will not be a vote or amendments or anything like that. We're just going to listen to the proposal and take it under advisement for a later date. Welcome to the committee.
Thank you, Madam Chair, members. I think what we'll do here is I'll have, in fact, I didn't talk to you about this, Representative O'Neill, but Representative O'Neill crafted this together based on certain considerations that have occurred over the course of the last 6 months now. And we'll have Representative O'Neill proceed first on why she thinks our proposal is important, and then I'll follow up with the details of why that's okay with you. Okay. Thank you, Madam Chair.
Morning, Representative O'Neill.
Good morning, Madam Chair and members. Thank you for having us here today. As you all know, we've had several sexual harassment issues within the House of Representatives that resulted in 2 members, 1 House, 1 Senate, leaving. And they did not go through an ethics committee hearing, which is concerning. I'm a strong believer in due process. I'm a strong believer in confidentiality. As you were just discussing, that most of these proceedings, unless the executive or the majority of the ethics committee decide that it should be private, are public. I have dealt with sexual harassment and sexual violence and other things legislatively for years, and feel that it's time. We haven't changed the rules since 2005 or 7, I can't remember, 2007. I think it's time to review them, particularly in light of the Me Too movement, particularly in light of there's a movement afoot among women to actually tell their story, and I think that we should be there on their side and be able to help them to tell their story. Something also became apparent as we moved through this whole process with these 2 members, again, 1 House and 1 Senate. The public really didn't have an avenue to launch a complaint. It was, you had to go through 2 members of either body in order to move a complaint. And I think that that is an important thing for the public to be able to do, that if a member is acting inappropriately, particularly with sexual harassment issues, that the public should have that avenue, and there just wasn't a clear path for them. So this offers a clear path for the public as well to file a complaint. So for those reasons, I joined with Representative Lesch, and we went over this proposal really with a fine-tooth comb, and he was gracious enough to make many changes that I had suggested and thought would make it better, particularly with some of my work in the past with sexual violence, sexual harassment legislatively. So, and I know we have someone from Mincasa here, so they graciously are in the audience today as well, but I've worked with them on many occasions to move our statutes forward to protect women in a greater way. So with that, I'll turn it over to Representative Lesch.
Thank you, Representative O'Neill. Madam Chair, members, I have been in the House now for 16 years, and over the course of those 16 years, you hear things. You don't know what's true and what's not, but I found myself over the years wondering several times about individuals that are here to petition their government for a redress of grievances or whatever constitutional right they have to be up here. And there are absolutely power dynamics at play. And I found myself occasionally looking at more senior lobbyists who've been around a long time, especially female ones, and staff members, and wondering the things that they have seen. You know, if these walls could speak, and would we be proud of the situations that our fellow members engaged in, or would we be ashamed of that? And I just don't know the answer to that. And as a man, as a straight white male, I am certainly not in that position to see as much of that as some of my colleagues or friends or lobbyists would be. So I found myself wondering about that, but with seemingly little recourse to do anything about it, or so I thought. In the wake of the Me Too movement, there was an additional willingness to understand and see what was really going on, especially in Hollywood, but also in politics. And when that occurred, I had conversations with several people, and with what the news reports that had happened around here, I began talking to folks Members, but especially lobbyists, because members have a certain unique recourse, an election certificate. It makes you different as a member. There are still absolutely power dynamics. But when you come up here as a citizen or as a staff member or as a lobbyist, there are absolute power dynamics which limit your recourse. So in considering this, I spoke with Representative O'Neill, and I would also be remiss if I did not point out that there are a couple members who did desire to, I think, weigh in on this. This proposal brought forward by Representative O'Neill and I is not perfect in any way, and I didn't intend it, we didn't intend it, I think, to be perfect. We intended it to be a conversation, because that conversation needs to be had. But I believe Representative Mayquade and Representative Beckerfin, they raised some concerns to me that they may want to bring up with this later. I've also raised concerns, I had concerns raised with me from several lobbyists that I know. And they said, they looked at this proposal and they said, you know, your Representative O'Neill's proposal still has me as a lobbyist sitting before a group of your peers who would sit in judgment of you. And I'm not going to put myself in that position. Okay, and that's a very valid complaint. It's an absolutely legitimate complaint. At this point, and I think this is a topic for this committee, I don't know how to get around that with the constitutional restrictions and separation of powers. We are very limited in what we can outsource for authority over us. We can still do it, but as was stated just previously, we are the ultimate arbiter under the Constitution of who sits in this body and who does not. So that's a conversation that needs to be had. There may be a way around it that I don't know about it yet. But with that, I would go into some of the thoughts that Representative O'Neill and I had about what should happen. Now, the conversation up until this point in the committee about the Ethics Committee, when I first came here 16 years ago, it was made clear to me that the Ethics Committee is the place where ethics complaints go to die, because it's split even up. And it's done that way for a reason, to protect against partisan bias. And so the suggestion is that things don't move out of there, because the only way to get something to the Ethics Committee is to have 2 members sign off on a complaint. And those are always 2 members of one party against a member of the other party, which means by design, it is a partisan process. Now, that's not always been the case, but it defaults that way often. I know that because I was part of that. Very early on, I was asked to do my job as a junior member to file an ethics complaint against another member, and I did it, absolutely not knowing what I was getting into at the time. And it turned out to be a completely partisan process. It was not pretty. It was ugly. I think Representative Erickson probably remembers that. Anyone else around here? Representative Erickson, I think you were the only one who was here at the time when that happened. I was disappointed with the process at the time. So when Representative O'Neill and I talked about this, we thought, okay, I can't necessarily do anything about that. That's a process that needs to be worked through with the Ethics Committee. However, when it comes to accusations of sexual harassment, which should in no way be partisan, we thought that, what about avoiding the tendency of something to go to the Ethics Committee to sit there because action can't be taken on it because it's split dead even? How about requirements, number 1, for timelines, where decisions have to be made by our own rules. Rules can only be undone on the floor by a 2/3 vote, which is high majority. So rules set in that say timelines have to be met. Number 2, protections for complainants/victims. Protecting them from being dragged through the mud by saying that at least the initial determination of probable cause is non-public. Okay, the protection that affords an individual who is in a negative power dynamic, such as a lobbyist, means that they do not have to go public with their complaint and risk their career. They can bring their complaint forward privately, and then the Ethics Committee decides whether probable cause exists for a complaint to move forward. After that, the complaint and the identities are public. However, the lobbyist, staff person, whoever it is, or member, has the protection of already having had their words validated by a probable cause determination. So it is much more difficult for them to be attacked as saying that they're making a frivolous or superfluous complaint because this determination has been established by a body of peers of the person who is accused. Again, these are areas that may be criticized, but these were the ideas that Representative O'Neill and I came up with. Also, the Ethics Committee has to bring on an outside consultant who can help make a determination based upon best practices, legalities in the workplace of what procedures are commonly used, and whether or not those procedures were properly followed by the House or by the member who was accused, or by the complainant, even for that matter as well. So the Ethics Committee is guaranteed to receive this advice from an outside individual who is an expert in the area. So that was another facet of it. One other piece that I think I wanted to point out about this issue is what Representative O'Neill brought up in the way of a public process. And this may be fairly criticized about it being a public process. However, when the Me Too movement occurred, there was a very public conversation in our nation about what is happening and what should happen. Now, we've had these conversations before. I was in law school during, Clarence Thomas and Anita Hill, and there was this big conversation, and, I still remember Jerry McGuire, what was that, 1991, where he made a move on his assistants. He's like, oh, I just pulled a Clarence Thomas. She's like, no, you didn't pull a Clarence Thomas. Yeah, I just pulled a Clarence Thomas. Well, that idea of that conversation going into pop culture in a major motion picture is a part of how we change behavior. It gets into people's heads subconsciously about, hang on a second, that's something that I can't do anymore. The only way that happens is if we have a public conversation about it. And my concern about what has happened over the course of the past few months is that there were summary resignations with no conversation. And I think when that happens, the conversation does not happen, and then there is not an effort to change cultural behavior. There is a consequence. Everyone, especially leadership, is allowed to say, well, we fixed that, we're good. Everyone's trained now, we're good. And as we know, I think that doesn't happen without a public conversation of what's proper and what's not, which is why we wanted this to be a public process whereby the culture of the place would change. So that was the first foray that we wanted to offer, and we fully expected that it would be fully vetted by this committee with hopefully a better product coming out the other end.
Thank you so much for bringing this proposal forward. We will open it up to questions now. Representative Fenton.
Thank you, Madam Chair, and Representative Lesch or Representative O'Neill. First of all, thank you. I know when you first presented this bill that in some of the media it was good bipartisan effort was recognized as a good first step. But I do have a couple questions regarding some of the language. Can you talk more about what a non-public probable cause hearing would look like? Who is that body that would make up the hearing process? Who are those people?
Representative Lesch.
So, well, thank you, and I'll say...
And that's from 2.30 on the bill, if anyone's wondering where I'm, line 2.30.
Thank you for that question. And Representative O'Neill and I talked about this. I will tell you my idea of what that is. That is the Ethics Committee.
Okay.
The Ethics Committee makes that probable cause determination in private, after which, and honestly, the standards for what probable cause is would be up to the Ethics Committee.
Okay.
So I don't know. But our intent in offering the language was that it would be the Ethics Committee that would be the probable cause determiner.
Okay.
Representative Fenton.
Thank you. And then I have a couple more questions, but pertaining to 3.12 and 3.13. First of all, what would be considered reasonable attorney cost?
Representative Lesch, an attorney.
Well, so, yes, now, these provisions are permitted in law in other situations, and like in a family law case, a judge finds attorney's fees permissible to be collected by the non-prevailing party. The attorney that wants to collect those attorney's fees has to submit an affidavit, what they charge per hour, and justify the hours. So if you come in and say it took 10 hours for me to draft this complaint, and any attorney worth their salt know that it's like you're talking 3 to 4, they would say, no, we'll allow the 3 to 4. Your fees are within the range of what we find permissible, so we'll permit that. But it's completely within the prerogative of the House to do that. But there are mechanisms for that in the law, Representative, in Article 3 courts, that I guess I would presume that we as an Article 2 institution would follow, but that would be up to the Ethics Committee as well.
Representative Fenton.
Thank you, Madam Chair. And if the accused, and again, I'm going back to section, starting in that paragraph, 3.12, if the accused were found to actually be guilty of the complaint, why should the House have to cover their legal fee?
Representative Lesch.
Oh, well, Madam Chair and Representative, they shouldn't.
Okay, so, okay.
Representative Fenton.
But it says accused and accuser in paragraph, complaint may request reimbursement by the House for reasonable attorney costs. And I know you give it up for approval by the House committee, but should there not be included something that states if found guilty, it should be out of your own pocket, or?
Representative Lesch.
Madam Chair and Representative, the operative word there being may, that if, I would not presume that the House would approve any cost for someone who was found guilty. But there is a scenario, I guess I could envision, where it's possible, that being that if the accused was not guilty and was completely innocent and was the subject of a completely unjustified smear campaign, I would probably expect in those scenarios, most of the times, the House would still not reimburse their costs. But there could be a scenario in there. But, we're not wedded to this language. If that needs to be changed, that could be changed.
Representative Fenton.
Thank you, Madam Chair, and Representative Lesch and Representative O'Neill. So I have an election certificate. If I didn't like this, or if anybody here with an election certificate doesn't agree with your proposal, they could have their own bill drafted and present something, correct?
Chair.
Representative O'Neill.
Thank you, Madam Chair. Absolutely, and we would encourage people to bring their own ideas, which we have. I know that Representative Lesch has spoken to his colleagues that had concerns and encouraged them to write something and bring something to this subcommittee and process it through the committee process. Absolutely, this is, I think, maybe one of the first things out of the gate in writing as a suggestion, but it certainly isn't, the perfect thing. But we're trying to bring something to have a conversation and move something forward.
Representative Schultz.
Thank you, Madam Chair. So I am concerned with language in line 2.22. And this section refers to sexual harassment and discrimination, that within 7 days after receiving a complaint, the leaders must refer the complaint to the Ethics Committee. Are you concerned that this would, as it stands now, would really deter people from coming forward if a complaint must go to the Ethics Committee, which you cannot assure confidentiality or privacy?
Representative O'Neill.
Thank you, Madam Chair. So the reason that we're doing that is so that we don't have any ambiguity, that these complaints need to be taken seriously, that these complaints need to go to the Ethics Committee, which is the proper place where it should go. And that's why we also included the evidentiary hearing part of it, the probable cause hearing, the merit part of it be non-public. So if that complaint is brought forward, there's still a condition where the Ethics Committee can be a closed committee. will review the evidence, they'll look at the reports, and that is a non-public hearing.
Representative Schultz.
Thank you, Madam Chair. To me, I don't interpret it as non-public, that you need the approval from the Ethics Committee to go into an executive committee, which is non-public. So to me, there doesn't appear to be an insurance that it would be private.
Well, Madam Chair.
Representative Lesch.
I don't know where it is in here now. The intent was, and I think it might be in, where it says the probable cause hearing is non-public. That's on line 2.29 and 2.30. And let me just clear up, it is our intent that any complaint, number one, it get brought by the majority leader and minority leader to avoid the suggestion that this is, partisan. It's not two members of one party, which wasn't your question, Representative Schultz, I know that, but the intent was that complaint is absolutely non-public. And I would add one thing here that I forgot to add. There is a companion bill on this proposed rule change that we dropped at the beginning of session 2. The reason that bill is required is because the Minnesota Data Practices Act, Chapter 13, does not apply to the legislature. And the privacy, the non-public nature of that complaint needs to be sacrosanct. And without the Minnesota Data Practices Act applying to the legislature, there is no legal incentive for a person like the accused who knows the identity of the complainant to remain silent. But by applying the Data Practices Act to the legislature, the accused or anyone who knows about the complaint is in violation of the Data Practices Act if they disclose the name of the complainant. We dropped that bill to make sure that those data practices penalties exist to ensure the confidentiality of the accuser / victim. And so that is the intent. If the language does not achieve that, then it should be fixed, in my opinion.
Madam Chair?
Representative O'Neill.
Thank you, Madam Chair and members. I would direct your attention to 2.30, where it says a non-public probable cause hearing is required. And just before that, it talked about all the components of that hearing, which includes the complaint, supporting material, all proceedings, meetings, hearing records, and so on. And everything related to is non-public, and that's pretty well spelled out, I think. And if it needs to be stronger, we can make it stronger, but the plain reading says a non-public probable cause hearing is required.
Questions? Representative Freiberg.
Thank you, Madam Chair. On line 2.18, it says that the complaint has to be delivered to the accused, but the complaint, in the complaint, it must redact any identification. It seems, I assume the intent behind that redaction is to protect the identity of the accuser. However, I mean, when we hear about these harassment cases, there are always very specific facts behind them, whether it's a text message with specific content in it or a specific action taken by the member. And it says on line 2.13 that the complaint about the member's conduct must present with specificity the factual evidence supporting the complaint. So it seems to me that even if you redact the identity of the accuser, it's not going to be very difficult in most cases for the accused to figure out the identity of the accuser. Do you have any response to that?
Representative Lesch.
I don't know how to fix that, Representative Freiberg. If you're being accused of something, you're gonna need to know what you're being accused of. Part of me, is I've got the shackles. Sometimes the liberties, being a lawyer, affords additional ability to do stuff, and sometimes being trained as a lawyer restricts that. But I am committed to certain principles, certain constitutional principles that say if you are accused of something that you should know what that is. But, you know, I guess I would wonder if there's another proposal about how to handle that. Because at some point, I'm presuming that everyone would agree that the person is entitled to know what they're being accused of. But I don't know. I guess I don't have a good answer of what a better fix for that would be.
Madam Chair.
Representative O'Neill?
Thank you, Madam Chair and members. You know, if the person that is being accused committed that particular act, of course, he's going to know who the other person was. I mean, that's sort of common sense that if he or she actually committed that act, he would know who he or she committed the act with. So, yeah, I don't know how you get around that, because if it's a legitimate complaint, they're going to know who it was that. If it was somebody that was making something up, well, that's a different story, and that's what the probable cause hearing is about.
Representative Freiberg?
I guess then what is the purpose of the language saying that the identification has to be redacted?
Representative Lesch?
Thank you, Madam Chair. The obvious reason for the redaction of the identification is to protect the discrete identity of the complainant. At some point, if probable cause is found, and even at the probable cause hearing, which the accused can attend, the accused will discover the identity of the accuser victim. But in the complaint itself, the intent was to follow standard procedures that we have in the courts, whereby a person is not named directly, but when it's a juvenile or someone who qualifies under, let's say, the Safe at Home program, we will use initials rather than their name, because it's not just the accused who we're trying to protect the victim from. It's also other people that may learn of the complaint, may find the complaint. If the complaint is leaked, we don't want to directly disclose who that is at the time. It's, I think, an art more of a science in protecting the identity of the victim, and I don't think there's any conclusive way to perfectly achieve it. That's the best answer I can give you.
Representative Portman?
Thank you, Madam Chair. And do I understand we're just hearing this on an informational basis?
Correct.
We're not voting. Representative Lesch, as a lawyer who's, I think, prosecuted and defended, one concept I guess I would just bring to your attention is that there's no requirement right now that I can find that the complaint be in good faith. And the way it's written, it sort of contemplates there are either violations or there are not violations. There are no alleged violations, which may be found not to be violations. And so I think addition of the words good faith and alleged in various places in the draft would make sense. The other thing that's, you know, I think it's good that you refer to on page 3, lines 3.4 and 3.5 to an outside investigation. I really think the tricky part there is you have the investigatory report coming before the probable cause hearing, but we still have this problem of we're all partisan members of the legislature, whether we like it or not, we have a party designation. So in order to determine probable cause, before we get to that investigatory report, we have 2 Democrats and 2 Republicans sitting in judgment. And I just, you know, I think as we search for a solution here, that looking for something that's a little bit more objective and outside of the political world is something that I'm going to be looking for as we consider proposals.
Thank you. Representative Lesch?
I'm sure, I think those are good suggestions, and you know, just ongoing thoughts. There being, now we do require that the initial complaint be under oath, but we do not have any requirement existing now as requiring good faith, and I think that's a fair suggestion and allegation. And second, something that Representative Horman, you brought up, made me think that it may be worthwhile to include something in there to require the Ethics Committee to establish their own findings. If they were to reject the recommendation of the outside counsel? Why? I mean, what's your justification for that? As we all know, a lot of actions taken against members around here, not like by the Ethics Committee, but by our caucus and stuff, depends a lot upon how much we like the person. It's absolutely true. And I've seen it happen time and time again where an annoying member receives more justice than a non-annoying member, so to speak, at times. And that's human nature. That's going to happen in any body. However, when we are required to establish written findings, I think that would be worthwhile. And I don't know if that would be well received by this committee, but it's just a potential way to go. If we are going to reject the determination of outside counsel, there ought to be a reason for that. It ought to be stated and established and reviewable.
Other questions? I just had one question. I saw that on line 2.17, a complaint must be in writing, and I was just wondering if you could give your thoughts on that. Or do you have any fear of maybe it having a chilling effect on the victim to have to put it in writing? Or if you could just talk about that a little bit.
Yeah, Madam Chair.
Representative O'Neill.
Thank you, Madam Chair and members. I don't know how else you move a complaint forward if it doesn't have some substance to it and in writing and under oath as is required to move in that direction. You know, I'm a victim myself, and it is hard. It's a difficult thing to talk about. It's a difficult thing to move forward, but you know, we have worked with MNCASA and we'll continue to work with MNCASA to look at, you know, how to protect a victim and help him or her through that process. But I don't know how else you would move it through without it being substantive and in writing, and unless you have a different suggestion. If it's, you know, testimony that's oral, I don't know if that's any easier. I would think, you know, for myself, being a victim, I would say that would be more difficult than just writing it down.
Do you have any thoughts on that, Representative Lesch?
Well, only that, you know, I am a little bit of a slave to the Article 3 system, that being everything that's submitted is in writing, is in some verbal express content, because that sets in place the expectations and standards that we follow. You know, I honestly, if the Ethics Committee wanted to consider statements exclusively orally or in certain instances orally, I think that, you know, that could be the Ethics Committee's prerogative. As I said, as a slave to the Article 3 system, it makes me nervous because it gets more nebulous. But it may well be that that could be unreasonable burden on the victim of an incident. I don't know.
Other questions? Well, thank you both again for working on this.
Thank you for
It's
considering
nice to see a bipartisan effort on an issue that should not be partisan, and I appreciate you digging into it, and we will continue to look through the proposal.